They may have, good, they may have record title to it, but until the foreclosure process is complete, they don't own it yet. Everyone understand her question? It's a very good question. I'm sorry I didn't make this clear last week, or last class. Even though the bank has a mortgage on the property, until the property is foreclosed, the bank doesn't have it yet. Does that make sense?
But I feel like if they bought the property, then they would be like even more in the hole. Like,
well, if say, I'll give you another example. Let's say you have a foreclosure sale, right? And let's say that magically the buyer shows up with all the money and gets it back. What does the bank have to do then? What are the bank's options?
Well, then they can get the money that the buyer owes them.
Or
outbid them.
Outbid them, right? The entire purpose, excuse me, the entire purpose of the foreclosure process is to give the buyer an opportunity to reclaim it. So until the foreclosure process is completed, the bank doesn't have it yet. Because it's always entirely possible that the original buyer shows up and pays for it. And let's say magically the original buyer shows up and makes an offer. If that offer is too low, the bank can outbid him. Right? Because at that point, if the bank is going through the foreclosure process, they think they can make a profit off of it. And so there's some dollar amount, whatever that dollar amount is, where the bank will say, okay, we're going to take it, or not. Now, the other question is, what happens if there's a foreclosure sale and no one bids, right? No one shows up. Because the bank's like, this is not even worth our time, we're just going to abandon the property. At that point, the house remains empty, which is what happened with Mr. Robinson. Remember the first class of the year with the adverse possession. So you actually have situations where no one even wants to bid at all. Does that make sense? Mm-hmm. But it's a very good question of why would the bank have to bid against itself if it already owns a property? But it doesn't. It doesn't yet own the property. That's the key point. Make sense? Mm-hmm. Sorry, my foot was hurting me. I got to sit down. I'm not sure exactly what happened, but I'm running around too much, I guess. Other questions? Yes.
With the reading, are we just going to stay just like keeping track?
Yeah. I'm going to update the syllabus. I think probably this weekend. Now that I have a sense of where all makeup classes are going to be. Mm-hmm. But I know the dates aren't right. Just whatever the next class is. Okay. So we're doing class 8 today, recording. Your first Langdell is on Saturday, from 12 to 1:30, 5:17. Caleb is very good. He's actually a high school AP government teacher. So he actually knows how to teach. That's not to disparage others, but Caleb is very good, and I think he will teach you guys very well. Okay? Any other questions before we get started? Oh, the attendance is running. I'm going to turn it off now. You didn't okay. I'm not going to tell you your day. It's going to be running every day we start. If I don't remind you, you got to check in your own. I'll do it. I'll leave it up for another minute, then I'll turn it off. But I'm not going to remind you every day. This is your responsibility. When you're lawyers, the most important thing you do is keep records for your billing. This is good practice. Okay. Anything else? All right. 30 seconds. Okay. So I want you to start thinking about this question. The question is this. A sells Whiteacre to B. Oh, that's bad. A sells Whiteacre to B. B never records the deed. Okay. A then sells Whiteacre to C. C does record the deed. So the question is this. I don't care about C here, right? I'm trying between A and B. It's valid. True or false? Okay, let's get a poll. And attendance. Okay. Okay, so that's your question. All right, and we're going to start the polling now. A is true, B is false. The transaction between A and B is valid. Okay, another 5 seconds or so. All right. Okay. All right, where did I finish up last time? Who's last up? Okay, what'd you put? Okay, you said it was true. Why did you say it was true?
I was thinking of the jurisdictions based off of the race.
Did I tell you what jurisdiction you're in? Does it matter what jurisdiction you're in? Actually, well, Mia, what'd you put?
I put true as well.
Why'd you put true?
Because even though he didn't record it, there was still a sale, and I remember in the book it said that just because it's not recorded doesn't mean the deed's not valid.
Okay, Bradley, what'd you put?
True.
All right, you want to put false? No. Oh.
I don't know, I thought it was false because if he doesn't, record the deed, there's no record of him being the.
But recorded for whom? There's no record for whom?
For seed to see that.
Ah. Anyone else? Anyone else want to say something? Virginia?
Well, I put false, but I didn't know why. It just seemed right. I'm gonna be honest.
You had a 50-50 shot, right?
Oh yeah.
Doesn't count for anything. Anyone else? Justin?
I mean, I put B as well. I was just thinking like race statute.
Yeah, I didn't mention any jurisdiction, did I? All right, so the answer is true, right? Yeah, the answer is true. But I want to walk you through why that's the case. Okay, 75-25. The reason why the answer is true, and someone muttered it while Philip was talking improperly, is the word subsequent. All this stuff about recording statutes, race notice, right? That stuff only matters when it comes to a subsequent purchaser. And I'll give you a very easy explanation why. Name tag? Yeah. Natalie. Natalie, is there any requirement or any need for A and B to have recorded their deed between A and B? Is there any need to record a deed there?
They don't have to. No.
Why not? There's a really easy reason why.
But they still have a contract between themselves.
And what do they know about it?
That it's sold.
Yeah, right? A and B don't require any recording because they know it. They signed the deal, right? You have a statute of frauds. You have a writing. So there's no requirement for A and B to ever record their deed because they know about it, right? If I go make a contract with Natalie, she knows about it, I know about it, there's no problem. So the deed between the two of us is valid. And let's say I sold Natalie some piece of fraudulent land, even if she never recorded it, right? Or I never recorded it, she can sue me. We're in privity. There's a clear relationship there. Bradley?
Why do we call it recording the deed instead of recording and changing the title?
Well, because what you actually record is the physical piece of paper, right? Remember the title is the legal relationship. Remember this from last week?
Yeah.
The deed is the piece of paper. So when you go to the courthouse, you're not handing them some metaphysical, philosophical ownership. You're giving them a piece of paper. You say, here, record this piece of paper. And they make a notation. We'll get to the actual recording process later. I want to finish this thought. The relationship between A and B is obvious. They were there, the two of them together, there's no doubt. The only time that transaction matters is when you have a subsequent purchaser who pays for it, right? This is the question I gave here. A sells Whiteacre to C, right? Then C records the deed. Once C is in the picture, then we have to go into the recording statutes to determine who prevails, B or C. But if it's just A and B, it's fine. This is, I think, one of the harder concepts in this topic to understand, that you have different relationships, right? I'll write them out, make it very easy for you. You have relationship between A and B, and then your relationship between A and C. You have to separate them. They're not the same thing, right? Because B can have a claim against A, and C can also have a claim against A, but they're separate entities. That makes sense. Tyler, is that a hand or are you just penning?
Oh, sorry.
That's okay. All right, is everyone okay with that? Everyone get that much, okay? Make sure you grasp that concept, because the entire nature of this class today is people committing fraud. right? You know the same pattern, right? In every case, someone screws up. And someone sells something they really don't own, or maybe they own only partially. Yes, Yusuf.
So what needs to be added to this typo to make it non-valid between A and B?
Nothing. The transaction, no matter what happens, B can always sue A. No matter what. Right? I don't care what C does, B can always sue A. But here's the rub, Yusuf, right? If C is considered the bona fide purchaser, right? B can't get the land, right? B can always go after A for damages, whatever, fraud, right? But he can't get the oil. He can't get the minerals. He can't get what he actually wants. The issue in these cases is Whiteacre, right? You guys don't care about damages for fraud. That's not what you care. If you go, who owns Whiteacre? And to determine who owns Whiteacre, then you go to the recording statutes. But B for A, so always for fraud. We never hear about those cases because generally by the time the land's sold, the value is not monetary damages, which is basically like your closing costs, whatever, right? It's the value of the minerals and the oil, whatever else is underground. That make sense? Everyone else okay with that? Okay. All right. So with this background, let's talk about the recording process. So first off, why do we need a recording process? And I'll show you what these things actually look like. I have some pictures. See this like monster book? Here, make it bigger so you can see it. Right? You see this? Yeah. Okay, you see that? So like before computers, that's what it looked like. It was this ginormous book that listed every single record in a given county at a given point in time. All right? And here's what an index looks like. Here, I'll make it bigger for you. Okay. So I'm going to just walk you through. So this is what's called the General Index of Deeds. And you see there are two columns. Okay? You ever read that okay? It's a little hard to read, but I think you can read it. The first column says grantee. Second column says grantor. This column says the kind of deed. This is the date of the deed. The consideration amount, that is the purchase price, and the description. So these are records from, what's that say, 1853. And you can imagine, you're back in the 1850s, and you go to your local county courthouse, say, here's my deed, and they write some information, right? And they put this in this book. If you notice, the dates are not really in chronological order, right? September, November, December, November, November, September, November. You see that? Why are they not in order? Right? Why are they not in order? Because people don't always record their stuff in a timely fashion. Right? This is human nature. People are lazy. Right? Whether you're in the year 1850 or 2017, people are lazy. If you don't go to record your stuff right away, the dates may not match up. So you have, this date of deed from 1853. Look at this one, 1850. So some guy waited at least 3 years to record his deed. Right? That creates problems. The problem it creates is obvious. If you don't timely record your deeds, someone who's doing a title search may not find it and may think that this property is owned by someone else. And where this really matters, guys, is where you have a fraudster. Again, assume a person's committing fraud in this class. Today, everyone's a fraudster. They're crooks. He sells it to the first person. He knows that person's not going to record it right away. Then the next week, he sells it to a second person. The second person's responsible. Says, all right, I'm going to go down to the court. I'm going to do my title search, right? And look, I don't see anything here. I'm good, it's mine. That's what we have recordings acts, to protect the subsequent purchasers who don't know and get basically screwed. I'll get to the grant or grant index. There's another type of index called a tract index. And the difference between the grant or grantee index and the tract index is instead of giving the name of a person, it describes the land. If you imagine you divide up the city into a grid, and it says you ever play Battleship, right? The board game Battleship, like E10, whatever, right? Or like Bingo maybe, right? I5, whatever it is. there's a grid, and you match it up, and then you see that's where the person lives. Very few jurisdictions have these sorts of grids. So in every major jurisdiction I'm aware of, Texas among others, they use the grant or grantee. I think that's all I have for that. But yeah, the purpose of these recording systems is to create an efficient way that people can understand who owned a piece of property at any given time. Now, has anyone ever done a title search? Did you raise your hand, Megan?
Oh, yeah.
Yeah, what did you do it for?
I work for a mud firm,
A mud firm. Tell us what a mud firm is.
municipal utility districts.
Okay.
So I do that all the time.
You do it all the time.
Yeah.
Oh, you're my friend today. Okay, so
Great.
tell. No, that's okay. Every semester you should have at least one. Someone does oil or gas. So tell us, what's the process you take when you got to run a title search?
Well, most of the time you just contact the county, and then, or there's also the online records. You just look in a book.
So you don't look in books anymore.
No, I mean, if you go to a really small county, then yeah, sometimes, but I don't do that myself, no.
How far back does your office require you to go with the title search?
It depends on what we're doing, but normally not that far back, just to find out who's the owner right now. And then,
Okay, so you don't go all the way back to the beginning, do you?
no, it depends on what we're doing, but no, not really.
All right. Anyone else have experience with title searching? Yeah, Thomas?
I worked for a law firm this summer, and one of our clients had a lien against her when she was trying to sell her property. And what ended up happening was she thought the lien was taken off, and it ended up like it was taken off. But when the transaction happened, this was like 2001, 2002. The other party put a lien on like 15 properties, and the county ended up removing the lien on 14 of the 15, and they just accidentally left it out. So I had to go down to the county office and pull out like the little slide indexes, like instead of books now.
How long did it take you to find what you're looking for?
It took 3 or 4 hours.
So you were there for a while.
Yeah, I was there for a while.
You eventually found what you're looking for?
Yes, and then they had all the papers jumbled together like that, not in any order. And then
Yeah, they're not chronological, are they?
Then I had to match the property, not like the name, but like the location of the property, like E10 or whatever, with the lien being discharged.
Ah, okay. So, anyone else? So I usually have one student, usually when I teach at night, who works for an oil and gas firm, and they do what's called patent searches, right? So you can imagine maybe if you're trying to buy a house, you're okay searching back maybe 20, 30, 40 years, 50 years, maybe even 100 years. But if you're dealing with a multi-million-dollar reserve of oil, you got to be careful. And they go back to before the Texas Revolution. They basically go back to Columbus, more or less, right? So there's this one passage in your book that I absolutely loved. Everyone knows what I'm talking about, right? This one, I'll read it for you. Or anyone from Louisiana would like to read it? Like God Made Louisiana. Anyone else want to read it?
I'm from Louisiana, but I don't like to read.
I thought it was a 2
Gentlemen, I am in receipt of your letter of the 5th of this month, inquiring as to the state of the title prior to 1803. This is page 699. The state of the prior to the title of the year 1803. Please be advised that in the year 1803, the United States of America acquired the territory of Louisiana from the Republic of France by purchase. The Republic of France previously acquired title from the Spanish crown by conquest. Spain acquired title by virtue of the discoveries of one Christopher Columbus, a Genoese sailor who has been duly authorized to embark upon his voyage of discovery by Isabella, Queen of Spain. Before granting such authority, Isabella, a pious woman and cautious woman, obtained the sanctions of His Holiness the Pope. The Pope is the vicar on earth of Jesus Christ, the only son and heir apparent of God. God made Louisiana. Now, if this was God made Alabama, it'd be followed by Roll Tide, but it doesn't quite work the same. So, I guess Philip, I mean, this is meant to be facetious, but there's something obviously missing here. What's missing here? There's a link in the chain that's not present. If this was a title search, I'd give it probably a D. A for creativity, though. What's missing there? Right? What's not present?
Native American.
Yeah, Indians, right? there were actually people on the continent before Columbus got here. So this title is somewhat facetious, but it establishes that when you want to be serious about your ownership of land, you have to trace it back as far as you can. And most oil and gas firms go back to, if not the Texas War of Independence, they go back to the Louisiana Purchase in 1803. They go back that far. And there's a reason why they go back that far. Because they don't want some distant relative showing up and claiming a fractional ownership of the reserves, right? That would be devastating. So when you're dealing with these very expensive reserves, you make sure you do your title, okay? So let's actually walk through the example of how to do this. It begins on page 697, but this is going to take us a few minutes. I want to walk through it. Okay? This will take us a little bit. So first off, Simone, what's the difference between a grantor index and a grantee index?
Okay, so I'm gonna do grantee first because that's what I remember.
Okay.
That's like me.
Good.
And
Yeah.
that's the person giving.
Giving?
Yeah.
Who-
Oh, I'm sorry, receiving.
You
sorry.
got that. You got that thing right. But you got it wrong again. Yes. Yes.
And then grantor is the person that's giving.
Okay. Good.
So,
So now give it to me in terms of buyer and seller. Who's who? Who's the buyer? Who's the seller?
the grantee is the buyer
Good.
and the grantor is the seller.
Very good. Thank you. Okay. So we all remember grantor grantee, right? We all remember grantor grantee. But now you have books about it. And I showed you this picture before. This is going to be a grantee index. And how do I know that? Because the grantee name comes first. So let's say you're looking to see who bought Blackacre, right? Who bought Blackacre? You may have a rough estimate of when Blackacre was sold. Maybe you do, maybe you don't. Right? But let's say someone told you, oh yeah, Josh bought Blackacre in 2005. Maybe they got the year off, maybe they don't, who knows, right? So what are you going to do? How are you going to start? You're going to go to the book for 2005, right? It's all on computers now, but you have to learn the book stuff, right? You go to the book for 2005, and then you go to the grantee index, right? And you go through every single page looking for Josh. Josh, right? Eventually, let's say you find Josh. That tells you another piece of information. Who did Josh buy it from, right? So once you have the grantee, in the very next column you have the grantor. Once you know the name of the buyer, then you know the name of the seller. And you also know, importantly, the date, right? The date's very, very important, right? And this index is actually not very good, but I like it because it's pretty. It only lists the date of the deed. It doesn't list the date of recordation, the date it was recorded. So those are the information you need, right? Who's the buyer? Who is the seller? What is the date of the transaction, right? And what is the date it was recorded? That's the information that you need. But that's only the first step, right? Because even if you know Josh bought Blackacre in 2005 from, say, Bill, how do you know Bill actually had it? What if Bill's a crook? Let's say Josh is a patsy, he's a fool, right? Maybe he is. You gotta go a step further back. So once you know the name of buyer and you know the name of the seller, you go back one more level. If you know that Bill sold it to Josh, at some point Bill was a buyer. At some point Bill's name will appear here in the grantee index. And then you got to search for years before 2005 of where does Bill's name appear as a buyer. And when you find that, who's Bill's seller? Who sold it to Bill? You go to Allard, right? Go to Allen, right? A. And you keep going all the way. The process here, it sounds confusing, but it's not. It's a gradual process of elimination. You say, okay, who has it now? Who did he get it from? Okay, who'd that person get it from? Okay, who'd that person get it from? Make sure that the chain is complete and that there are no links missing in the chain. Because if there are any links missing in the chain, the person who's currently there may not be the correct owner, and you probably shouldn't buy the property. Right? That's why this is an important task, to make sure as you're the buyer today, that what you're getting is what they say they're selling.
You're not gonna flip-flop between the grantee and the grantor, though. You're gonna.
You stay in one book all the way back,
Okay.
and then you flip to the other book and go forward. I'm going to explain this in a minute. Lauren, you're on my next question. You're right on point. But you have to see, is the person today the record owner, or is there a gap in the chain? Even it's possible there's a gap in the chain. The person today maybe actually acquired it. Maybe by adverse possession. Don't forget about adverse possession. It's a very easy way for me to test this, right? Very easy way for me to test this. Even if the person is not the record owner, if he's been there for a decade, he may acquire it through adverse possession. Or maybe he acquired it by virtue of the recording statute, right? The recording statutes, which we'll get to later today, are designed to protect innocent buyers, right? They're designed to protect people who bought something where the seller was a crook. Or maybe the seller didn't know, maybe the seller was mistaken. So even if there's a missing chain in the title by adverse possession or by a recording statute, it can be saved. Maybe not, maybe yes, but it's possible, right? So it's not the end of the world if the recording statute is a problem. I'm sorry, if the chain's a title, but it's probably problematic. So what I want to do is walk you through the example. It starts on page 696. This is going to take a few minutes, okay? I want to walk through this step by step. Okay, so everyone with me. All right, so the example starts, right? Okay, so Chester, you want to buy Blackacre. And the seller, his name is Dubik, right? So Dubik is selling it to you. The first thing Chester wants to do is saying, okay, does Dubik actually own this land, or is he trying to fraud me? Because again, assume everyone's committing fraud. I promise you, they're all fraudsters. So Chester, you're a smart guy. You're buying this house. You're not going to take this guy's word for it. What do you do?
I'll check the record.
Okay, good. So where do you start? All you know is that this guy named Dubik is selling you Blackacre. That's all you know. What's the first thing you do?
That means he once was a buyer before
Yes, so good. So where do you start your search?
on the grantee index.
Exactly, right? Let's work this through. So we know Dubik, right? Dubik is the seller. But before Dubik was the seller, Dubik was the buyer. So we search the grantee index for Dubik, right? Again, it's not difficult, but just conceptually, whoever is currently the seller was a buyer, right? It's obvious. He bought it at some point beforehand. So we know Dubik was the buyer, so we go to the grantee index, and Chester's right. And again, the grantee index lists the buyers. So let's say today is 2017, right? We go the 2017 book, the 2016 book, the 2015 book, right? We keep going year by year, searching for every single instance where the name Dubik appears. And this is a fairly, odd name, but imagine it was a common name like Elliot, right? The case of later today. Imagine how much time it's going to take you to search every single transaction with the name Elliot in like 30 years in Houston. This is not an easy task. I saw a hand somewhere. Bradley.
If it's just a gift, is the gift receiver just a grantee then?
Well, even if you get a piece of property as a gift, you're going to record it so that way people are aware that you're the record title.
So yeah, maybe
Yeah.
a grantee.
Yeah, I mean, I want to go back to the picture I showed you before, but there's a column that says type, right? It says kind of deed. So you can actually specify a gift or a mortgage. Whatever it happens to be, you can specify. Okay. All right, so that's so trust. Okay, you're good. So the first step, we look at Dubik is currently the seller. That means he was the buyer. We'll search the grantee index for Dubik, right? Dubik. Okay. So the book says we keep searching, flipping back, and we see that in 1977, right? In 1977, there's a deed from Dubik to Cotter. And if you notice, these are all C and D. I will make your lives easier in the exam. The names will be alphabetical order. They'll be A, B, C, and D. They'll be in order. It might be like Adam and Bob and whatever it is, but they'll be in order, so it makes your life easier. So we know in 1977, there was a deed from Dubeck to Cotter. Okay? Is that Walker?
Yes, sir.
Okay, what's your next step? You just saw this deed finally after flipping through 40 something years of paperwork. What's your next step?
Well, it should be to do that from Cotter, right? Within the book.
I'm sorry, sorry. Yeah, so you got to Dubeck from Cotter, right? Right.
So you would.
Thank you for correcting me.
Go backward and find where somebody conveyed that interest to Cotter.
Yes, right? So you have to search, where did Cotter get it from? And again, you're still in the grantee index. And you flip back, 77, 76, 75, 74, right? And then you get to 1952. And you get a deed to Cotter from Barker. You get back from Carter to Barker. All right? Everyone with me? Okay, Yusef, what's your next game plan after this?
Continue doing the same thing.
So what are you looking for in the grantee index at this point?
For when Barker.
Yeah. So you start flipping back. Barker's name, the grantee index, go 1951, 1950, 49, et cetera, et cetera, et cetera. The book doesn't even give you the full thing, but they just say, you go back to 1900, and you determine that Oliver was the owner. Okay? So this traces it back about 100 years. That's probably good enough for most people. After 100 years, it's unlikely someone will assert a claim to it. Maybe it's possible, but not likely. But your job is not done yet, right? Recall again, this was all in the grantee index. Once you go back as far as you want to go, you switch books to the grantor index. And the reason why is you want to see, okay, I can trace it in terms of the buyers. Let's see if I can trace in terms of the sellers. And there's an important reason why. Very often the sellers are more proactive in recording paperwork than the buyers. The buyer's like, all right, my house, screw it, I'm done, right? But the seller's like, okay, I sold this, let's get rid of it. Or maybe the opposite. Maybe the buyers are lazy and the sellers are like, wow, I want everyone to know I bought this house. So this double system was designed as a fail-safe, that in the event that one party was responsible, the other party will back them up. And the reason why this two-track is important is it very often happens that one party records on date A and another party records on date B, and you need to figure out the differences. So any questions on this so far? Yes, Lauren?
So, with this, but going back and dating back, how does statute of limitation play a role? Because at some point, the previous owners will no longer matter because they can no longer come in.
Because they're dead?
Right.
What with their heirs?
So there's no statute of limitation?
Well, the statute of limitation kicks in if there's an adverse possession claim, right? But let's say they don't meet the element of adverse possession. You can actually have someone's great-great-grandson show up and say, hey, that's mine. Right? It wasn't notorious. Or maybe if there's an old jurisdiction, no hostility, right? You didn't meet the requirements of adverse possession. You didn't use it continuously, right? I mean, you could, there's no tacking, right? You can make up 100 reasons why. And I mean, again, with the house, it's silly, right? But again, imagine this is an oil reserve worth millions of dollars. You're going to find some great-great-grandchild come out of the woodworks, like, hey, that's mine. Give me a share, right? He has nothing to lose. So that's why you want to go back all the way as far back as you can go. Make sense? What's
Because I still feel like at some point somebody has adversely possessed.
Not necessarily though, right? Because again, I'll give you an example. Let's say that there's no tacking and you don't get continuity. Or let's say you're in a jurisdiction that requires you to have hostility. Remember that was one of the claim of right. If you don't have hostility, you'll get adverse possession. So if the adverse possession claim fails, then the grandchild shows up. It's like, okay, that's really mine. You didn't acquire it. The statute hasn't run yet.
Okay, so tacking does not always.
Not always, it's not 100%. Sometimes you can't prove it. Right, sometimes you can't prove tacking, maybe you can't prove hostility, claim of right, and there are a lot of reasons why adverse possession might fail in different jurisdictions. Alright, Bradley.
Kind of goes along with that a little bit, kind of a weird question. If somebody claims, makes a claim against property and it's, 150 years in the making or whatever, can you think of any possibility where they would use the law back then to assert a claim now? Does that make sense?
Yeah, why wouldn't they? No, in fact, the in Texas in particular, the Texas Supreme Court has said that all the law from before Texas joined the U.S. as a republic is still good law, right? So the case law from the Texas Supreme Court before Texas joined the United States is still valid law. In fact, if you have Professor Paulson for anything, for any classes, he teaches a number of classes. He actually has a commission from the Republic of Texas. I think he's the only person left, where the Texas Supreme Court, because it's a continuous body that existed before independence, right? It actually issued him a commission to be the official reporter of decisions from these old cases. He discovered these old cases from like 1840s, right, or maybe the 1830s, that were never published before. And in order for them to be published, you have to have an official reporter of the Republic of Texas. So he actually has on his wall a commission from the Republic of Texas. And technically, under the statute in effect at the time, he should be paid in gold pieces. I think he waived his payment. But your question is exactly right. Old statutes are still in effect in Texas. They've never been rescinded. So you can still cite them.
So is there any kind of issue, like some kind of choice of law between the parties that they would fight over, like using today's stuff compared to using old stuff? Does that make sense?
I'm sorry?
So if I'm the guy that wants property and my great grandparents had it, right? I'm gonna want to probably use the old stuff, the old statutes and stuff, compared to the current owner, if you will. They're gonna want to use the new stuff. Is there some kind of choice of law type issue or anything?
Well, if the question is, did your great-great-grandparents acquire it, then you consider the law in effect at the time. Right? It's not a choice of law. It's if that transaction was valid, the current person doesn't own it, and the current law is irrelevant. Okay, other questions on that? All right, so let's do the grantor index. Right, that's the next step. We have to. All right, Thomas. So where do we start?
You start with, in this case, it would be Oliver.
Okay,
You
good.
work your way from back to.
Very good. So you start in the year 1900 in the grantor index, right? Okay. You start in the year 1900 the grantor index. And then what do?
You work your way to present day.
Okay. So you see, at what point is the name Oliver appears, right? Right? You search Oliver in 1901. You search Oliver in 1902. You search Oliver in 1903. And the book says you get to 1915, and you see a transaction from Oliver to Anderson. Conveniently, right? You see a deed from Oliver to Anderson, so that's your first transaction. Okay? Jarrett, what do you do next?
Then I'm gonna go to Anderson and see who he sold it to.
So how do you find Anderson from that point?
You go starting forward from there.
From what year?
I guess it would be 1915.
Yes, sir. So you look for Anderson's name in the grantor column. Right? 1915, 1916, 1917, 1918, etc., etc. Now, eventually, you find a deed that's recorded in 1939 from Anderson to Barker. Okay? But you see that the transaction date is 1934. This is not uncommon, right? People don't record stuff right away. Right? So what do?
You start from 1934.
Who was the record owner of Blackacre from 1934 to 39?
record owner?
Yeah. Yeah. Would anyone have known that though? Okay. So, follow me here. This was the question I asked at the outset of class. Between A and B, B has a superior claim starting in 1934. But to the rest of the world, no one knew about it because it wasn't recorded. So let's say during this period, A was a crook and sold it off to someone else, X, right? X would have no way of knowing about this transaction because B was lazy. He didn't get on it quickly enough. All right. So the issue for you to remember is separate always. Is it valid between A and B? Yeah, that's valid. What about between A and X, someone else, subsequent purchaser? Okay. So now I think Lauren, you're next. What do you do next after you learn that there was a transaction from 1934, but it wasn't recorded till 39? What do you do next?
I would try to see if there was anything recorded for that property in between that time.
Exactly. So you start in 1934. And Lauren, why do you start in 34 not 39? You're exactly right.
Because if you start at 34, then there could have been another transaction or something.
Yes. And what name are you looking for in 34? You're actually looking for...
I guess I would look for Anderson.
And?
Under grantee.
Anderson and? You're searching for two names, really.
Oh, that's Oliver?
Not Oliver.
Barker, I'm sorry.
Yeah. You want to search between 34 and 39, right? Search for both Anderson and Barker. And let me explain to you why. First, Anderson may be a crook. Anderson may have decided to sell the land the next year in 1935. But this is what's going to blow your mind, guys, right? Barker never recorded his deed, but he may have sold it. Right? Barker never recorded his deed. Right? But he may have sold it. So if you want to be sure, you want to be certain in your transactions, you're going to search in that period between 34 and 39 to see if either of them made any transactions. Because again, Barker could have just said, all right, whatever, I'm going to sell it, people know about it, I'll be in the name. So unless you're searching for Barker, you'll miss it. You got to search for both names. Everyone see that? I'm doing this very deliberately so you follow along, okay? Justin, what's your next step?
So, once you find out there was no transaction between 34 and 39, you continue to look under Barker in the transfer index.
You're right.
Next, purchase.
Yeah, once you get to 39, you can stop looking for Anderson. He's out of the picture. But when you get to 39, now you're looking for just Barker. And then we see that from 1939 till 1952, Barker was owning it, right? And then 1952, there's a deed from, was it Barker to Cotter? Okay? Okay? And then, Lana, what do we do next?
You search under Cotter's name.
Very good, very good. And you go up and you see that in 1977, there's a deed from Cotter to Dubeck, right? And then, Elaine, just finish up. What's our last step?
You see it as Dubeck.
Yeah. You search from 1977 to 2017 to see, did Dubeck sell it? Right? Did he sell it to anyone? And if the answer is no, he is the record owner. Right? He's the record owner. You've now traced the title all the way from top to bottom and bottom to top. Questions? Jared?
So on the old records from 1800s where you only have a transaction date and they don't record a recording date,
That's unfortunate.
You have some problems.
It's very unfortunate, yeah.
Would you hope you're in a jurisdiction that use the index track that you can search that as well?
Most will have some sort of an index, and most modern jurisdictions will record both the date of the transaction and the date of the recordation when it was recorded. So I show you that picture because it's like an old-fashioned, it looks pretty, but it's not very helpful at all. And in fact, the showing it to you illustrates why it's not very helpful. Questions? Right? If you don't understand what we just did, go back and watch the video again. It's not complicated, and the reason why it's important to grasp is the concept of this. In order to know whether a subsequent purchaser for value is safe, you need to understand the sequence and the chronology of how transactions occurred beforehand. If the sequence is not understood, you will not get the questions right in the exam. So I can make this as easy as I can. I'm not going to make you spend 30 minutes tracing a title on the exam, but I will give you a fairly complicated set of facts where different people are buying and selling, recording at different dates, and you're going to have to know who has the strongest claim, this person or that person. Go look at the old exams. They're all pretty predictable, right? I promise you, you'll have someone who sells a piece of property to two people. It's going to happen. Without fail, I'm going to test you on this. And I don't need you to do this going back to 1900 business, but you're going to need to know who has a stronger claim at any given point in time. Make sense? Questions? No? All right. Now let's go on to the cases for today. The cases for today aren't about how to trace title. We just did that. The cases today concern fairness, right? What should we expect buyers to know when they make a purchase? In other words, what is the universe of information that's available to them? If something's not recorded, people can't be expected to know about it. And in some cases, like the last one, even if it's recorded, maybe they can't rely on it. So the first case, Luthi versus Evans, includes what's called a Mother Hubbard clause. I actually had a student a couple years ago. She graduated. She came back. It's like, Josh, I was at my firm and we had a Mother Hubbard clause, and no one at my firm knew what it was except for me. I'm like, you're welcome. Totally random. She said, like, out of the blue, I was like, great, I was only knew what it was. So good that you remember this case. Who am I up to? Lindsay, what is a Mother Hubbard clause? Such a funny. Everyone know the nurse from Old Mother Hubbard sat in the cupboard. She had like all this stuff in her cupboard. Remember that? Yeah. So what's this clause, Lindsay?
For the grantor gives the grantee like all of their property or something like that.
Yeah. So this was the issue in Luthi v. Evans, right? You had this clause in a contract, and it said that the seller will convey all interests owned by them in the county, whether or not enumerated above. All right. So it's basically saying, I am going to give you all the property they own in a given county. Lindsay, what's problematic about this sort of provision?
Sometimes you might not know what's included in there, what's not included.
Sometimes? Would you ever know?
No, I guess you would never really know because there's no like land descriptions and
Okay.
the same and contain you everything.
Right. So the case notes that these sorts of clauses make sense if you have a deathbed, right? Someone's on their deathbed, they're about to die, and they don't have time to list all their various assets. So it's like, all right, son or daughter, I'm giving you everything, I can't specify it. But in the context of a regular transaction, these clauses are problematic precisely because you don't know what they contain. So Megan, let me ask you this question, right? Let's say someone in, I think it was Kansas, executed one of these Mother Hubbard clauses. How would you record that, right? How would the person at the county clerk know to record that she's selling all of her assets in the county? How would that even be done?
They don't.
Yeah, why not? They can't what?
They can't determine what property is what.
Well, sure they can. I mean, can't the government know who owns what? I mean, there's one way of doing it. How can it be done? How would you determine all the property owned by was it Luthi? I don't remember. By Grace and the Winockers, Grace Owens, right? How would you determine all the property that Owens owns in a given county? It can be done, can it? Yeah, right? It would take you a long time, but you'd have to go through every single page of the grantee index in that county and search for Grace Owens. Every page in the last how many years, how long she's been alive, and maybe those of her ancestors also. So it's entirely possible to trace all the ownership of the property. But that's burdensome. That's a lot of work. It's a lot of work. And moreover, let's say that you don't know about Grace Owens, right? Let's say that you're trying to purchase some land from Byers or someone else, right? How are you supposed to know that a given piece of land came from Grace? Grace, right? How are you supposed to know that? It's very difficult. So, Robert, what does the court do here with this Mother Hubbard clause? How do they treat it?
What was it said? It's valid, I guess, in terms between the two parties?
Yes. So I'm so glad you said that. That was my third question. You'll do it first. There's no problem as between Grace and the tour company that this Mother Hubbard clause is valid, right? There's no doubt. If I say, I, Josh, want to give you, Robert, all my property, that's fine. The problem, however, arises only if a third party, a subsequent buyer, comes into the picture. And Robert, does the court say that this Mother Hubbard clause is sufficient to put on notice third party subsequent purchasers?
No, it isn't.
Good, why not?
What, just because the fact that they're not specifying, I guess, the land or like the property that's being given. It's just, it says everything. So in this case, they had everything in one county, but then the seller ends up selling one piece of it to a second person, and when they do the title search, they can't find it because they don't have that specific piece of property. It's just the only thing they have is the Hubbard clause, which says everything in the county.
Very good. Very good. So the court here holds that the Mother Hubbard clauses are not valid for purposes of subsequent purchasers. They're fine between the buyer and the seller. That's no big deal. But it does not put a subsequent purchaser on notice that these pieces of property were conveyed. Now you can imagine why the buyer wanted this, right? He was probably trying to take advantage of these people, I'm guessing, and said, oh yeah, just sign this, whatever, right? Give me all of your property. He didn't want to have to go through case by case. Now, there's a risk though. There's a risk, because the buyer didn't do his due diligence, right? Maybe Grace didn't actually own these things. He said, yeah, give me whatever you have and I'll flip it off. So there's something problematic about this sort of transaction. Okay? And here I actually have a picture of the index. Okay? So this is the grantor index. It says Owen Grace, grantee international tours, time of reception, and again, this only lists the date it was received. It doesn't list the transaction date. Okay? And then here you actually have the details. It signs and interest, and it gives the volume, the page number where it appears, and it gives the meets and bounds of where it's described. So this is generally what you're dealing with, but there's no meaningful way in a Mother Hubbard clause to record it so that people will be on notice. Yeah.
Is it known as the Mother Hubbard clause when it involves personal property?
I think so. Yeah, I think it's often used in terms of a deathbed confession. That's often where it comes up. Yeah, again, I thought it's the funniest thing. One of my students graduates like, I was the only person at my firm who knew what this was. So it's stuck in her head. Maybe you too will know this with this one day. A lot of law students don't even learn adverse possession either. I didn't learn it when I was in law school. So one of my students said, I was the only one of my associates who knew what adverse possession was, and none else learned it. So you guys had the curve. All right, so any questions on the first case, on the Evans case? Yes, Chester?
So it's the duty of, like in the example of the Andy, the duty of B to receive the mother hubbard.
Well, here I think B asked for the mother hubbard clause.
But it's the duty of him to afterwards fix it up if he were to sell it.
Can it be fixed up though?
If he knew what the property was.
But if he knew what the property was, why would he get a hubbard clause? See, if you know what the various interests are, you don't want this. This is risky, right? This is risky. This is easy, but it's risky, and it came back to bite him. Lauren.
Well, that was a question I had in my mind too, because in the case it spoke about even with the Delta transactions, the person is in imminent of death is not going to have the time to go and figure out exactly what they're about to give. But the buyer, or the person who's receiving the transaction, at some point they will be able to go back and figure out exactly what was given.
But do they have to get specific conveyances from Grace Owens, new conveyances to specify it? And what if she doesn't play ball? Right? Well, even if they find out about it, it doesn't matter if you can't record a transaction. So unless Grace Evans is willing to sign new paperwork, it doesn't matter. The time to specify the specifics is at the time of the transaction, not sometime later.
So there's no duty for the receiver or the buyer to go in.
Look, she signed the papers he gave her, right? And between the two of them, that's a valid transaction. It only matters for third parties. Chester?
So we're saying that, like, in that situation, a subsequent purchaser is always going to, and depending on the jurisdiction, whether it's race or notice, will have a better claim than the person receiving the mother.
Well, let's unpack this, right? The reason why the subsequent purchaser has a better claim is because the Mother Hubbard clause is not valid, right? The Mother Hubbard clause didn't put him on notice, so therefore the subsequent purchaser prevails.
But the clause is valid for just A and B.
Yes, right? A and B is valid, right? Let's give you an example, right? Let's say that C never came to the picture, it was just A and B. And let's say Evans gave Tour Company this Mother Hubbard clause. And let's say that Evans started trespassing the land, starting to drill on it. B could evict her, right? The tour company could evict Evans if she was trespassing, because between the two of them, it's a valid clause. Only when a third party comes in does this become a problem.
And if it's so risky to have this type of clause, why would you ask for it?
I get my sense in this case, Yusuf, is that this was a speculator who wasn't really concerned. He just wanted people to sign stuff quickly and flip it away for money. This is not a smart business transaction. This was done in a quick, whatever, sign it. Like, kind of like the last case also where they got the woman to sign it and they ripped up the paper. I think it's the same type of deal. Grace Owens didn't sound like a sophisticated buyer, and this company was, I think it was a Delaware company, whatever. I mean, they were trying to get money out for her. Yes.
Isn't she the one who sold it again?
Yeah. So the joke's on them, right?
Yeah.
Yeah. So I think we have two fraudsters here. I don't. Maybe I'm wrong. Maybe Miss Owens was sophisticated. Maybe she knew exactly what she was doing. She's like, screw this. I'll give you guys a Hubbard clause. It won't be upheld in court, and I'm going to sell it to these other guys. Maybe I'm wrong. I don't know. The joke's on them because Owens made out like a bandit, right? In that case, Tor can sue Owens for fraud. I mean, if that's how it shook out. Yeah, you never know exactly you always think, the company was all sophisticated and these poor humble farmers, right? Or whatever. Maybe they knew what they were doing. All right. Any other questions on the first case? All right. So don't use Mother Hubbard clause. But the lesson that you actually have to take away is, if a document doesn't describe with particularity, specificity, who owns what, it's not good enough to put you on notice. You have to have specificity, particularity. All right. The second case I don't want to dwell on too long, but it raises an issue that can be very problematic, especially before computers, right? So you have Elliot, If Elliot, right? You have 3 ways of spelling the exact same name. Fairly common names, fairly common spellings. When you're doing a title search, are you obligated to search for not only the name of the person you're looking for, but also the variants and potential different spellings of the name? So, William, what does the court hold in the Orr versus Byers case?
So they basically said that it's way too burdensome to ask somebody to do that.
Very good. Why is it so burdensome to search for the different variants of the names?
Basically it would just take way too long, and you're trying to assume that you know every different way to spell something.
Yeah, very good. So this is a doctrine known as idem sonans, right? Idem sonans, which basically means it sounds like, right? So even if a name is spelled incorrectly, if there's some name that sounds similar to the ear, similar spelling, courts can rely on it. The doctrine does exist, but here they're not particularly concerned about extending it to property, because as William mentioned, it creates a burden. The facts here actually illustrate why being a careful lawyer is important. And we all screw up, we all make mistakes. But what happened here is that a client obtained a judgment, right? A judgment. And a lien was put on property. But because the lawyer misspelled the name on the lien, it didn't show up. And my friends, if you spell the name on a lien, it's not valid, right? And as a result, the client lost out a lot of money. So the client sued the lawyer for malpractice. Right? That's what happens if you screw up, you get sued for malpractice. It's your fault. You couldn't even spell your own client's name right. It happens. I mean, we're all human. But what actually happened in this case is that the lawyer was basically standing in the shoes of his client, because he already paid off the client to go away. And the lawyer was hoping that if he won this case, he would get some money out of it. He didn't. He didn't get anything out of it. All right. That's all I want to say about this case. The doctrine doesn't really apply of idem sonans. I do want to get to the recording acts, though. So go to page 715, please. There, 715. All right. There are 3 kinds of recording acts. I'll jump to the question you asked me. Texas has a notice statute, but I'll very at that question. But there are 3 types of recording acts. There's race, there's notice, and there is race notice. Okay? Again, these statutes only matter between the buyer, between a subsequent buyer and the seller. The key word there is subsequent. You don't need recording statutes when it's just A and B. Only when a third party is involved. This is a question I asked at the beginning of class. The original transaction from A to B, recording statutes don't matter because they're both aware of it. They were there. They signed it. They don't need a recording statute to protect them. But the purpose of a recording statute is to protect the subsequent or the successive buyer. All right? Kaylee, read for us example number 2 on 715, please.
Owner of Black Acre conveys Black Acre to Dave, who does not record the deed. O subsequently conveys Black Acre to B for a valuable consideration. He actually knows of the deed to A. He records the deed from A to B under a race statute. B prevails over A, and B owns Black Acre.
Okay. I want to give you a phrase which you've probably seen in contracts, but a subsequent bona fide purchaser for value. Can't spell. A subsequent bona fide purchaser for value. Or just to be short, a subsequent BFP. You seen like a BFP, this phrase? Okay, now you've seen it. A subsequent bona fide purchaser for value. What does that mean? Someone who in good faith purchased the property for money. The value actually matters because if you didn't purchase it for money, the recording statute won't protect you. It doesn't concern gifts. So if you're a subsequent bona fide purchaser for value, you can try to avail yourself or take advantage of the recording statute. Right? So let's go back to example number example number 2, I'm sorry. O, the owner of Blackacre, conveys Blackacre to A, who does not record the deed. O subsequently conveys Blackacre to B for consideration, right? B is a subsequent B is a subsequent bona fide purchaser for value. He's a subsequent BFP. Now, B knows about the deed to A. He knows about it, but he buys it anyway. He records it. Under the race statute, B wins. It's called a race statute because it's a race to the courthouse. Whoever gets there first to record prevails. B wins. So even though A acquired it, because he sat on his remedies, he loses. Now, the benefits of a race statute is it's very easy to apply. Right? It's easy. Who recorded first? That's it. You're done. You don't need to determine state of mind. The downside, of course, is that it's not very fair. Right? It leaves A in a very tough spot. Even though B was aware of the transaction, he bought it anyway and recorded. Everyone with me? So the race statutes are easy. The downside is they're not very fair. They exist in only 2 states, our neighbors to the east, Louisiana, and North Carolina. So this is not anywhere even close to a majority rule. The most common one, and indeed the one that prevails here in Texas, is what's called the notice statute. Okay? And it states that if the subsequent purchaser had notice that there was some prior transaction that was never recorded, the subsequent purchaser cannot prevail. Let me say it again. If there was a subsequent purchaser that had notice of some prior transaction that was never recorded, the subsequent purchaser cannot prevail. And example 3 is an example of this. You want to read it first, Amy, please?
O, owner of Blackacre, conveys Blackacre to A, who does not record the deed. O subsequently conveys Blackacre to B for a valuable consideration. B has no knowledge of A's deed. Under the notice statute, B prevails over A, even though B does not record the deed from O to B.
Okay. So here's the situation. O sells Blackacre to A, he doesn't record. Okay? O conveys the same property to B for consideration. B is bona fide, he has no knowledge of A's transaction. Right? Under the notice statute, B wins. B wins. Even if B never recorded his deed. Why? Because he was a subsequent purchaser for value who took without notice. That's where the name comes from, notice. Right? Now, Amy, I'll ask you the follow-up question. What if B knew about it? What if B knew?
That would be notice, so he wouldn't know.
If B knew that this other transaction existed, let's say someone mentioned to him, right? Does that change the answer?
B knew that A had, so he has notice.
And so can he take advantage of the recording statute?
Not if it's notice.
So who wins?
A.
Okay. Good. Right? If B actually knows about it, B cannot prevail. Okay? But then A's got to do something. See, that's the rub. It's not enough just for B to have knowledge. What does A have to do to prevail, though? What do you think? Record. Right. A then has to record. Yeah.
When you buy a property, are you kind of filling two roles in this chain, I guess? How to explain? Because wouldn't you at the same time be starting a new relationship, but also be a subsequent purchaser and then hold?
Say, I think I lost your question in the middle.
So like, I mean, there's no like new owners of property anymore.
Of course not. No, everyone takes it from someone else. Yeah.
When you buy a property, are you the subsequent purchaser for a
Yes, you're subsequent from somewhere else, right?
But you're also the new purchaser from the person who.
Let me give you another example. I think this might answer your question. Okay. Let's say this, right? Okay. A sells to B, right? No, I'm sorry. What is it? I'm sorry. Oh, so basically the same example we had before, right? Where O sells to A and O sells to B. Okay. What if A records after B buys it, but before B records it? Okay. In this case, A records first, and B loses. But now here comes Anna's question, right? B sells to C. Okay? B sells to C, a third party. What happens here? If you're C, what are you going to do? You're going to search the titles, right? And you're going to find A transaction, right? A already recorded the transaction. If you track far enough, you'll find A. Right? So if you're C, you're going to know that something happened funky in the chain. And because you have notice, you can't take advantage of the recording statute. Everyone see that? If A records first, right, in this situation, A's deed is a matter of public record. So even if B tries to sell it, C now has the obligation to find that A deed. And if C finds an A deed, he cannot take advantage of the recording statute. Yusuf.
So all A has to do is to give notice to record?
That's it, right? After that, it's off his hands. Once A records it, he's told the world that this is mine. And even though, right, even though C doesn't know anything about A, C knows about O, right? C knows about B, knows about O. So C can be able to track down the A deed. It's not easy, but they'll track it down. Yeah?
Well, hung up on the first question mark part.
Yeah?
So A records it after B buys, right?
Right.
So when B bought it, he wasn't on notice that A...
Yeah, and that's the rub. That's exactly why this is weird, right? When B bought it, there was no way for him knowing about the A transaction, but he recorded it subsequent to that. But C can now determine that this A transaction is there, and C probably shouldn't buy the property.
But why does A win and B lose in that first part?
Because the example I gave before is that B knew about this prior deed. And if you have notice, you can't take advantage of the recording statute. It's tricky, right?
Yeah, I was just reading that. Like,
right here, let me explain this out, right? Because B knew about O's sale to A, B cannot rely on the notice statute. That make sense?
Yes, sir.
Okay, good. Everyone get that? Chester?
When we say be new, we're honest, are we saying solely off of checking the record, or is there any other?
It could be anything, right? Even if he, his neighbor told him, right? That counts. There actually are cases where, I think we'll have one later this semester, where some neighbors said, oh yeah, something happened to this property 20 years ago, right? And that was notice, that was enough. But the difficulty with the notice statute is it requires, this is Chester's question, how do you know what you know, right? What if you play dumb, right? What if you say, oh, no one told me, I never knew. So if there's an actual recording in paperwork, that's easy, right? You can find that. But it's like, yeah, some neighbor told you, I forgot, I didn't pay attention, memories fade. So the upside of the notice statute is that it's a little bit more fair. But the downside is it's really tough to apply. It's really tough to apply. Yes, sir.
So there's no should have known, it's just whether they knew or not.
Yeah. Well, if there's a record that proves it,
Yeah.
that's knowledge, right? Whether they found it or not, that maybe they're lazy. But the fact that this deed existed from A, that's it. The existence of the record is sufficient to put them on notice.
So if they don't record, it's bad or hard to argue that they should have known if they really didn't.
Well, if they never recorded, then that's a lot harder, right? The record doesn't exist. Everyone think, Bradley.
I'm just wondering about the trend, like which type came first.
Which statute?
Yeah, like.
The notice statute is far more popular today.
But which came first? Was it
Well,
race?
initially race. Race used to be a lot more popular because it's easy, right? This is hard to apply. And in our remaining minutes, let's go to the last one. Right, the last one is the most annoying. Of course, it's from California. I was in California yesterday, so whatever. Race notice. You know, Californians here?
No, I wish
I'm always somewhere else. I was there for a very short period. I barely saw the water. I saw it from the Uber, basically. Race notice. Race notice, okay? With a race notice statute, the subsequent purchaser is protected against prior unrecorded transactions. If two categories are true, right? First, the subsequent purchaser had no notice of this prior transaction. And second, the subsequent purchaser must record first, right? In order for the race notice statute to be satisfied, the subsequent purchaser must not have had notice and must be the first to record. And it's a mouthful, but look at example number 4. I think it's on the next page. David, want to read for us, please?
Number 4. O, owner of Blackacre, conveys Blackacre to A, who does not record the deed. O subsequently conveys Blackacre to B, who does not know of A's deed. Then A records. Then B records. A prevails over B because even though B had no notice of A's deed, B did not record.
Okay, very good. Thank you, David. So let's walk through this one step at a time. Okay? Again, O conveys Blackacre to 2 people, A and B. Initially, A doesn't record. So that way, when B makes a transaction, he has no idea, right? How is B possibly supposed to know about this if A never recorded? Okay? Under a notice jurisdiction, David, who wins here? Just with those facts.
Under a notice?
In Texas, notice jurisdiction, who wins here? Who wins? No. What did we say a minute ago, right? In a notice jurisdiction, who's protected? No. Who's protected? Go to your notes. We did it 1 minute ago. Who's protected in a notice jurisdiction? We just did it 2 minutes ago. Read your notes. Who's protected in a notice jurisdiction?
Because B knew about that.
Who's protected in notice jurisdiction? Yes, and in this case, is B the subsequent purchaser? Did he have notice? Okay, so under a notice jurisdiction, this question we have here, B wins, right? But why is this different in a race notice? What changes?
Because you have to add the factor in of who was listening.
Yes. The biggest difference between the notice jurisdiction and the race notice jurisdiction is this additional requirement of recordation. Who records first? Right? Who records first? I'll do 30 seconds, I promise. Okay? In this case, A records first. And because A recorded first, B cannot prevail. You need to have two things are true. The subsequent purchaser lacks notice, and he records first. Here, you only have half of that. He didn't have notice, but he was not the first to record. Therefore, B loses, and A prevails over B. Lauren?
Well, wouldn't that also be the case in notice? Because if I don't have notice and I record, but A got there first, wouldn't A take it automatically at that point?
No. No, with the notice jurisdiction, right, the recording isn't important, right, between the two of them, between A and B, right? B will prevail over A if he takes it without notice. Even if A records, that might matter for some third party. But between A and B, B prevails over A. In contrast, in California, in order for B to prevail over A, he has to record first. That make sense? Robert?
How do they, I guess, measure it? Is it by day or is it by hour?
Well, look right here. Go back to the picture I showed you a minute ago with the, you see that? It measures, I mean, it's on the board, right? It measures the date, the hour, the minute. You have cases where, imagine two people are online at the office at the exact same time, and one guy like goes to the bathroom or something and misses class for a minute, right? And you know, they miss the they miss getting called on. Problematic. Sorry, I'm making it too obvious. Yeah, I had to skip over. I'll come back to you later. Yeah, it's a problem. So timing matters. Make sense? All right. Bradley.
Just thinking of like people online and they knew it was, you know, they were
Yeah, right.
Is there some kind of thing about good faith or like not pushing someone out of the way?
Look. Let me answer your question a different way. Let's say that person A was the first in line, right? And he recorded, but like the clerk went for a lunch break or something, right? And didn't actually put it to the book till after lunch. And during that 1 hour lunch break, person B did his title search. Can you sue the clerk for having a lunch break? So generally speaking, the subsequent purchaser is going to be out of luck here, right? Because if the paperwork was filed, that's probably enough. But I'm certain there are cases where the guy brought his paperwork on time, and then the guy took a lunch break, and during that like 1 hour lunch break, right? You know, the other guy came and did his title search and didn't find it. But because the record was in existence, you know, maybe you should do your title search twice, right? Maybe you should check whatever. But you probably have luck. All right. We're short on time. The last case is not too important. I mean, it's important, but it has to do with attestation. Attestation, which basically means a notary. The reason why a notary is important is it verifies that a person is actually signing what they say they're signing. And indeed, if a document was not properly attested, that is, it doesn't have a proper notary on it, because the woman wasn't even there when she signed it, it's not valid. Why this matters for our topic is this. If you're doing a title search, and you're looking at various deeds in a book, how in the world are you supposed to know that the notary was not valid? There's no way for you to know that whatsoever until you have litigation. So that this ruling, I think, is actually quite unfair. Because the subsequent purchaser did everything in their power to check it out, but because the notary was not valid. Okay, so let me summarize a bit to give you something to bring home with you for the long weekend. Oh, and again, your Lindell is on Sunday at Saturday at noon. So the purpose of these recording statutes is not to provide a rule for A and B, right? The buyer and the seller. The purpose of the recording statute is to help subsequent purchasers, right? In the race jurisdiction, it doesn't matter what you knew. All that matters is how quickly you got to the courthouse to record. The notice jurisdiction provides a wrinkle that if you were a subsequent purchaser for value and you didn't know about these other earlier transactions, you're good, whether or not you record it. The race notice, this is the one they have in California, has a wrinkle that the subsequent purchaser without notice prevails only if he records first. So even if you bought property and you were unaware of these earlier transactions, if the other guy beat you to the courthouse, you lose. So the lesson for all this, if you remember nothing else, is to timely record all of your transactions and give your lawyer an easier time. Or the flip side is, maybe one day a client will come to you and hire you because they didn't properly record stuff. Questions? All right, I will see you all on Tuesday. Good luck with the Langdell session. Thank you very much.